It's The Law with Morelli Chertko. This time I'm joined by Elizabeth Harris. Hi, Elizabeth. How are you?
I'm well. Thank you, Howie.
We're going to be talking about motor vehicle accidents, employment law, occupiers' liability. First of all, let's start with, do I need an employment contract?
Well, the thing is, Howie, that everybody has an employment contract. As soon as you're hired to do a job, you've got a contract. The real question is whether you need that in writing. In my experience, written contracts are very, very rare, and that just leads to questions on both sides. So ideally, yes, you should have a written employment contract that spells out everything that you need to do, everything the employer needs to do, and everything that the employee needs to do.
I imagine most people do, or do they go by the wayside in a number of positions?
In the vast majority of cases that come across my desk, there is no written employment contract.
Really?
Yeah, which is why you come to a lawyer.
Right. Okay. So what happens if I'm fired from my job?
Well, if you're fired and there's a written contract, then the first place the lawyer goes to find out the answer to the question is the written contract. And ideally, that would set out what happens if you're terminated. But if there is no written contract, then the lawyer has to look at what a judge would do in those circumstances. And they look at the reasons why you were fired, how long you were at that employment, the responsibility that you had at your job. A number of factors go into what should happen when you get terminated.
Now, on the other end of the spectrum, if I, as the employer, have an employee that's just not working out, what can I do?
Get some advice early on. Most of the problems that come across my desk are when an employer makes a decision quickly just to fire the employee because they've dropped the ball on one, in hindsight, minor issue. Normally, when an employee just isn't measuring up, there should be a progressive steps that the employer takes of discipline, warning them that they need to make some changes. If those changes aren't done, making the same warning again, but in writing, and saying what the consequences are going to be. And then the last stage would be another written letter saying you've been given these verbal and written warnings, you still haven't done what you were supposed to do, now you're terminated. The problems arise when the employer just terminates the employee early on without giving them the opportunity to remedy their situation and remedy their work.
In a large amount of cases, do people consult a lawyer? It just seems like most people just walk out the door and say, I guess that's that.
That's hard for me to say because I am the lawyer that's being consulted.
Right.
So I'm seeing more employers consult me early on to ask if they have cause to terminate an employee. I'm also seeing more employees consult me when they think that something is going to happen and they're not quite sure how to protect themselves against something that they feel is coming down the pipe. So I'm getting more advanced questions, which is good because then it's always cheaper to get advice early on than after the fact when litigation is a more realistic possibility.
What about if an employer changes your job description significantly?
Yeah, that's an interesting question and a really difficult area of the law. It's called constructive dismissal, and it's exactly as if you had been terminated from the job that you were hired to do. So when you're terminated from your job completely, saying don't come in the next day, then everybody knows that, well, I've been fired. And then you ask the questions, well, should I have been given notice of that? Should I have been told that was going to happen, or should I be paid something because I didn't have notice? The same thing happens when you're told, for example, you're working in Kamloops and we're transferring you now to Prince George. That's a significant change in your job. Or you were office manager and now you're going to be director of finance. Another significant change potentially. So the real question that needs to be answered is whether the change that the employer has put on you is significant enough and fundamental enough to be considered constructive dismissal or wrongful dismissal. If it is, then same considerations apply. You need to be either told in advance that this is going to happen or paid money.
Is it a very specific type of criterion?
With constructive dismissal, it's gray. There's as many answers as there are questions. So there is no easy answer to that one, and oftentimes the lawyer is going to be scratching their head as much as the client is when they come in.
Okay, what about severance? What are people entitled to?
There's a really good question too. There's 3 different things that are going to govern that. One is that written contract that I talked about that ideally should spell out how much the employee is going to get if they're terminated without cause. The second criteria is what does the legislation say? And in BC we have the Employment Standards Act that says you're entitled to a certain number of weeks of notice, up to a maximum of 8 weeks, depending on your length of employment. And then the third criteria is common law or judge-made law, and that's just what a judge thinks is a reasonable amount of severance or notice that you should have been given when you were terminated. So 3 different things that a lawyer is going to have to look at, and ultimately a judge is going to have to look at. If there's no written contract and the statute, Employment Standards Act, doesn't apply, then the considerations that a judge is going to look at are things like the employee's age, their degree of responsibility, the length of their employment, their ability to get similar employment elsewhere. All of these factors come into play when a judge decides how much notice was a reasonable amount to give. The other thing that a court considers is whether the employee could have or should have got work elsewhere. So an employee just can't sit back and say, well, I was terminated. I should have got 2 months notice, so I'm not even going to look for the next 2 months or look for work for the next 2 months.
Right.
They've got to go out and do something. And if they don't, and the judge decides that they should have, what the judge is going to do is deduct what the judge thinks they could have earned in that period. So again, not an easy answer.
All right, there's Elizabeth Harris and employment law on this edition of It's the Law with Morelli Chertko.